Welcome to RD Investigations, Rubber Ducky Video Channel. For procedural history, trial court, Darlie Routier was indicted for capital murder on June 28, 1996 in Dallas County, Texas, in connection with the June 6, 1996 death of Damon Routier. On June 28, 1996, the court appointed Douglas Parks and Wayne Huff to represent Ms. Routier. Due to pretrial publicity, a change of venue to Kerr County was granted on September 27, 1996. On October 21, 1996, the court granted a motion to replace court-appointed counsel with Douglas D. Mulder, Curtis D. Glover, Richard C. Mosley, and S. Preston Douglas, Jr. Ms. Routier was tried by a jury before the Criminal District Court No. 3 of Dallas County, Texas. Jury selection commenced on October 21, 1996, and was completed on November 18, 1996. The guilt phase of the trial began on January 6, 1997, and the jury returned a verdict of guilty of capital murder on February 1, 1997. On February 3, 1997, after hearing evidence during the penalty phase of the trial, a jury returned an affirmative answer to the special issue concerning future dangerousness and negative answer to the special issue concerning mitigating evidence. According under Texas law, Ms. Routier was sentenced to death. Direct appeal. In March of 1998, the Texas Court of Criminal Appeals held the trial court reporter Sandra Halsey in contempt for failing to complete the trial transcript despite numerous extensions. In April of 1998, Ms. Halsey filed the transcript with the Court of Criminal Appeals. In October of that year, the court ordered Judge Robert Francis to conduct an independent review of the transcript after Ms. Routier's appellate attorneys discovered over 30,000 discrepancies in the transcript. Judge Francis found Halsey's entire record to be so deficient that it had to be replaced entirely. Another court reporter, Susan Simons, was appointed to prepare, certify, and file a new reporter's record using stenographic notes in Ms. Halsey's original transcript. The tapes used by Ms. Simons, however, were often of poor quality and unauthenticated, and Ms. Halsey's notes were inaccurate and incomplete. In April 1999, Ms. Simons testified that she had reconstructed the transcript to the best of her ability. The record was delivered to the Court of Criminal Appeals in December of 1999. Over defense objections, including Simons' refusal to certify the first 54 pages of Volume 10, which contained the notes of a hearing on October 21, 1996, at which Douglas Mulder was substituted as Ms. Routier's trial counsel, the court issued an order finding that it had complied with all prior orders of the Court of Criminal Appeals and had satisfied petitioner's objections on September 7, 2000. The conviction and death sentence were affirmed by the Court of Criminal Appeals on May 21, 2003, in a published decision, Routier v. State. State Habeas Corpus Petition. Mrs. Routier's state habeas corpus application was timely filed under applicable state law on July 12, 2002. During the pendency of her state habeas corpus proceeding, Ms. Routier repeatedly moved the court for the right to access and test the evidence that she contends will prove her innocence, including the following: expedited motion for access to state's physical evidence, May 29, 2002. Renewed request for access to state's evidence, July 2, 2002. Post-application motion for access to state's evidence, July 17, 2002. Second renewed request for access to state's evidence, July 29, 2003. Motion for reconsideration, November 3, 2003. Motion for forensic DNA testing, November 4, 2003. renewed motion for testing of physical and biological evidence, and request for an evidentiary hearing January 23, 2004. The court did not grant Ms. Routier's motions for access to any of the state's evidence, nor did the court allow any sort of forensic testing. The trial court issued its findings of fact on August 4, 2004, ruling that the petition should be denied. The Texas Court of Criminal Appeals agreed, denying Ms. Routier's petition for a writ of habeas corpus on December 1, 2004. Petitioner will request a stay of these proceedings until the state court resolve her pending DNA testing motions. In connection with her state habeas corpus proceedings, Ms. Routier filed 3 motions that remain pending before the Criminal District Court No. 3 of Dallas County, Texas. 1. Applicant Darlie Lynn Routier's motion for forensic DNA testing filed November 4, 2003. 2. Applicant Darlie Lynn Routier's supplemental motion for post-conviction DNA testing filed on January 28, 2005. And 3. Applicant Darlie Lynn Routier's motion for discovery regarding pretrial DNA testing results filed on January 28, 2005, collectively the DNA motions. The state trial court has not yet decided these motions, and the trial court judge has informed counsel for both parties that he intends to resume proceedings regarding the DNA motions in the near future. Out of an abundance of caution, petitioner is filing this petition for writ of habeas corpus less than 1 year after the Texas Court of Criminal Appeals denied her application for a writ of habeas corpus. Nevertheless, proceedings regarding the DNA motion are still ongoing in the state's courts, and it is likely to be a significant period of time before the pending motions are finally determined. Petitioner therefore respectfully submits that the time is not yet ripe for this court to proceed to the merits of this petition for writ of habeas corpus by the person in state custody, and will move this court to grant a stay of these federal habeas corpus proceedings until such time as the Texas courts finally determine the matters presented in the 3 pending DNA motions. 5. Claims for relief. Darlie Routier was denied her 6th Amendment right to effective assistance of counsel. Trial counsel was constitutionally deficient in 2 respects. 1. Representation was hampered by an unwaverable conflict of interest between Ms. Routier and the only other adult in the house at the time of the murders, her husband. And 2. Trial counsel utterly failed to investigate or rebut the purported staging evidence that lay at the core of the state's case. Trial counsel's divided loyalties between Darlie Routier and her husband constituted ineffective assistance of counsel. Relevant facts. Douglas Parks and Wayne Huff were the first attorneys appointed to represent Darlie Routier. Parks considered Ms. Routier's husband, Darren, a suspect and planned to introduce evidence against him at trial to create reasonable doubt about Ms. Routier's guilt. Affidavit of Douglas H. Parks. Douglas Mulder represented Ms. Routier's husband and mother, Darlie Key, during a show cause hearing on September 20, 1996, where the state alleged that they had violated a gag order regarding Ms. Routier's upcoming trial. In a conversation with Darlie Key and Darren Routier, Mulder informed them that Parks intended to implicate Darren in the crime as part of the petitioner's defense. When Darren and Darlie Key learned of Parks' strategy, they sought to replace him with counsel who would not accuse Darren. Mulder agreed that if hired to represent Darlie, he would not argue as part of the defense that Darren Routier was in any way responsible for the death of his children. As a result of this promise, Darren and Key asked Mulder to represent Ms. Routier at trial. On October 21, 1996, Douglas Mulder became counsel of record for Ms. Routier, replacing her court-appointed attorney, Douglas Parks. Even without knowing about Mulder's agreement to suspend any investigation of Darren, both Parks and counsel for the state believed Mulder to be incapable of representing Ms. Routier because of a conflict of interest. In an October 24, 1996 letter to Mulder, Parks stated that he continued to believe that Darren Routier was a possible perpetrator of the offense. In the same letter, Parks further advised Mulder that the court had not addressed a possible conflict of interest generated by the simultaneous representation of Darlie and Darren Routier. Parks' concerns were more than just mere conjecture. On November 12, 1996, the state filed a notice of possible conflict of interest with the trial court alleging that Mulder's previous representation of Darren created a conflict that jeopardized Ms. Routier's Sixth Amendment right to conflict-free counsel. The state filed the notice to make real sure that there was no constitutional violation since the state had found some new evidence implicating Mrs. Routier's husband. That notice stated in relevant part that the investigation was ongoing with regards to the analysis of physical evidence, and recent analysis of physical evidence suggests that Darren Routier may have participated in the crime. When the trial court addressed Ms. Routier in open court on November 12 and November 18, 1996 about the state's notice, Mulder did not state on the record his opinion about whether a conflict existed. In addition to these warnings, Mulder was aware of several significant pieces of evidence implicated Darren Routier in the crime, including 1. His hair on the murder weapon. 2. The bloody sock found in the alley contained fibers from his bloody sneakers. 3. Inconsistent statements about his bloody jeans. 4. Blood on his jockey shorts. 5. His inconsistent statements and suspicious behavior at the crime scene and hospital. Mulder failed to even investigate these leads. Ignoring the evidence available to him and warnings of conflict of interest, Mulder kept true to his word. The only evidence that he introduced implicating Darren was not offered until the punishment phase of Ms. Routier's trial, when the information could no longer be used to harm Ms. Routier's husband because she had been convicted. Mulder's non-adversarial questioning of Darren during the guilt phase of his trial. You know, it's curious to me, and I have never, for a minute, doubted the innocence of Darren Routier, but you know, he of all people had the most to gain here. She had a couple $100,000 worth of insurance on her. If Mulder had not been burdened by a conflict of interest, he would have learned that in the spring of 1996, Darren Routier was contemplating an insurance scam that involved staging a burglary of his home. Darren Routier asked his wife's stepfather whether he, quote, knew of anyone who would agree to burglarize his home as part of an insurance scam. Darren Routier explained that he and his family would be gone from the house and that the burglar would come to the house with a U-Haul truck and remove gobs of stuff from the house, which he would retrieve after the insurance company paid off. Darren Routier had admitted that he had this conversation with Robbie Key only days before the attack on his wife and children. Nor was this an isolated instance of Darren's willingness to engage in insurance scam. 2 years prior to the murders of his 2 children, Darren Routier arranged to have his Jaguar stolen so that he could collect the insurance proceeds. That crime went without a hitch. I spoke to a person about my Jaguar automobile. In that conversation, I said that it wouldn't bother me if the Jaguar was stolen. That person then stole the Jaguar. Had Mulder taken even minimal additional investigation steps, he likely would have uncovered the above-listed evidence implicating Darren. Darren's intent to stage a burglary at his home could have explained several items of evidence that the prosecution could not explain in its case in chief. First, there was the issue of a mysterious black car that numerous witnesses testified they saw in the neighborhood around the time of the attacks of the Routier's home. Question. Well, it was earlier that day she was working, whatever day that was. Answer. Right. But she saw, yes, she did see a black car in the back alley, and when he passed us by really fast, or a black car passed us by, she said she saw a black car in the back alley. When she was in the garage, he was sitting and waiting for somebody, but he was looking into the garage. Question. Like he was watching the house? That's what your mother told you, wasn't it? Answer. Something like that, yes. Testimony of Karen Neal. Answer. I came home from work about 3 o'clock in the afternoon. I saw a small black car that was stationed right in front of my sidewalk. Question. Okay. And how was that small black car parked in that area? Answer. It was against my curb, and the person in the car seemed to be angled towards the Routier house. Question. All right. And you told the jury that he appeared to be focused on the Routier house? Answer. Yes, sir. Question. Okay. Did that strike you as unusual? Did you say anything to him or do anything or go to the house or answer? When I got out of my car to approach him, he sped away very fastly. Second, there was testimony regarding two suspicious men, one of whom fit Darlie's description of her assailant walking along a stretch of Darlie Road, approximately a 10-minute walk from the Routiers' home sometime after 2:00 a.m. on June 6, 1996. Affidavit of Darlene Potter. None of this information was presented to the jury because defense counsel failed to pursue a line of investigation to uncover such evidence. Legal basis for the claim. When a defense attorney actively represents conflicting interests, the prejudice prong of the Strickland test is presumed. Mickens v. Taylor. The term conflict of interest means a division of loyalties that affected counsel's performance. Conflict of interest has detrimental effects on representation because of what it tends to prevent an attorney from doing. Finding that the trial counsel's conflict of interest constituted ineffective assistance of counsel, citing Holloway v. Arkansas. Also, Sanders v. Ratelli. The harm may not consist solely of what counsel does, but of what the advocate finds himself compelled to refrain from doing, not only at trial but also during pretrial proceedings and preparations. In this case, defense counsel Mulder had divided loyalties to Darlie Routier and Darren Routier. As a result, his assistance to Darlie Routier was ineffective. Mulder suffered from two distinct conflicts. One, he represented Darren Routier in a matter substantially related to this case, and two, he agreed not to pursue an obvious defense strategy as a precondition to his representation. Each separately provides more than sufficient basis for a finding of ineffective assistance of counsel. This error is not harmless. The error is plainly not harmless. If Mulder had investigated Mrs. Routier's husband, the insurance scam would have been uncovered and presented to the jury. This would have been more than sufficient to establish reasonable doubt as to the identity of the killer and undermines confidence in the jury's verdict. Defense counsel's failure to investigate and rebut physical evidence that lay at the center of the state's case constituted ineffective assistance of counsel. Relevant facts. Mrs. Routier's court-appointed counsel Douglas Parks and Wayne Huff retained two forensic scientists, Terry Laber and Barton Epstein, to consult with the defense on physical evidence. Laber and Epstein had been given access to a variety of crime scene evidence, including Miss Routier's nightshirt, photographs of the blood spatter in the garage and utility room, the garage window screen, and the bread knife from which a fiber was recovered. Laber and Epstein's preliminary finding was that the evidence was consistent with Darlie Routier's testimony, and she and her sons had been attacked by an intruder, thereby contradicting the state's theory that Routier had staged a crime scene. Also, affidavit of Barton Epstein in support of petitioner Darlie Lynn Routier's renewed request for access to state's evidence in reply to state's opposition. At the time of our work was stopped on the Routier case, our preliminary findings were that at least some of the physical evidence we reviewed was not consistent with the staged crime scene. Laber and Epstein recommended the testing of key physical evidence, including the bread knife, Mrs. Routier's nightgown, Hoover vacuum cleaner, carpeting, Darren Routier's jeans, and pillow and furniture. Laber believed not merely that such testing was possible, but that it was necessary. In my professional opinion, scientific testing of the physical evidence would have been critical to Miss Routier's defense. Independent testing of that physical evidence was crucial to properly evaluate the state's case. There were numerous potential holes in the state's case that required testing to conform and refute the state's presentation of the evidence and to provide evidence that could well have refuted the state's forensic testimony. These and other tests would have been critical to developing the physical evidence to refute the state's use of forensic and physical evidence and establish Ms. Routier's innocence. In October of 1996, when Douglas Mulder replaced Parks and Huff, Mulder and his investigator had a perfunctory meeting with Laber to discuss the scientific analysis he and Epstein had conducted to date. During the meeting, Labor provided a general overview of their work. Mulder and his investigators asked virtually no questions about the work and generally were uninterested in Labor's analysis. In total, the meeting lasted about 2 hours. Labor expected that Mulder or someone from his defense team would follow up with him because the time to the introductory meeting was not sufficient time to explain in necessary depth the forensic significance of analysis Barton Epstein and I had performed or had recommended be performed. Labor did not hear from Mulder again, however. At trial, the state presented the testimony of a number of expert witnesses who claimed the crime scene had been staged by Miss Routier. Charles Lynch, an expert from the Southwestern Institute of Forensic Scientists, SWIFS, provided key testimony that microscopic debris recovered from a bread knife found in the kitchen at the Routier's residence was consistent with material from the garage window screen and therefore likely was the instrument used to create the T-shaped defect in it. Ms. Routier had testified that the intruder exited the home through that torn window screen. Lynch testified, question, bottom line, from this comparison of the black rubbery material and the glass rods on the window screen and on this knife, what does that say to you as trace evidence analyst? Answer, I couldn't tell the difference between the debris and the debris found on the knife, and therefore the knife could have been used to cause the cut defect. Question, okay, are you saying that the material that you found on this knife blade is consistent with the material that makes up the screen right here? Answer, that's right. Question, you couldn't see any difference? Answer, that's right. The state confirmed the significance of this testimony during its closing argument. When Lynch tested cutting the bread knife, he looked at it under the microscope, and what did he find? Glass rods, the same type of rubber material as seen on the bread knife, and the same type of rubber debris with the glass meshed in. The same type of stuff that happens when you cut the screen. And it adds up. And the bread knife was used to cut the screen. And Charles Lynch found that evidence. And that tells you they were trying to fake the crime scene. You aren't going to have an intruder somehow get in the house and then take the knife out and then cut the window. Tom Bevel, the state's blood expert, said he conducted several experiments to determine the type of pattern a bloody knife would leave if it had been dropped by the intruder when exiting the garage. When asked to compare a photograph of the pattern created in his experiments with photographs at the crime scene, Bevel testified. Question. Now, looking at the state's exhibits 38A through 38D, Mr. Bevel, do you see any bloodstain pattern in any of these 4 photographs that correspond to the types of blood patterns that you saw during your test on November 26, 1996? Answer, no, sir. Question. The blood drops that we see in 38A through 38D, are they consistent or inconsistent with the bloody knife being dropped or thrown on the utility room floor on June 6, 1996? Answer. They would be inconsistent.